Hello and welcome to our naturalisation webinar. I'm Cathryn Davies, a solicitor here at Carla Solicitors. I'm also joined by my colleague Carla Mirallas Martinez, an experienced solicitor on our team. Applying for British citizenship is quite an exciting stage for our clients, as it essentially marks the end of perhaps a quite long and costly immigration process. Carla and I are pleased to be able to provide information today on the naturalisation process and its requirements, and we hope you find it useful. At Carter Thomas, we provide advice and assistance on all areas of personal immigration law. Our key areas include partner and family visa applications, indefinite leave to remain, also known as settlement applications, citizenship applications, which we're discussing today, which includes naturalisation and registration, EU settlement scheme applications, visitor visa applications, and global talent endorsement and visa applications. In this session, we'll be covering automatic acquisition of British citizenship, what is naturalisation, how to apply, the requirements for referees, the eligibility requirements for naturalisation, and we'll have a short case study at the end. Of course, this webinar provides a general overview of the naturalisation process and therefore cannot be taken as legal advice. For advice tailored to your specific circumstances, please do reach out to us. So then, before we get into naturalisation itself, one thing to consider is that some individuals may acquire British citizenship automatically, and in such cases, they do not need to apply to naturalise and can instead apply for a British passport. We have included some examples here on when a person may automatically have acquired British citizenship. So an individual born in the UK after the 1st of January 1983 is automatically British if either parent was British or settled at the time of their birth. Individuals with British citizenship otherwise than by descent can also pass citizenship onto their child born outside the UK. So a person may be British otherwise than by descent if they acquired British citizenship in their own right, such as through naturalisation or if they were born in the UK. So then what is naturalisation? Naturalisation is the most common way for adults to acquire British citizenship. Individuals who do not automatically acquire citizenship may choose to apply to the Home Office to naturalise. Typically, a person considering a naturalisation application will have obtained indefinite leave to remain, also known as settlement, by completing a period of qualifying residence in the UK. The length of that residence depends on the person's immigration route. Naturalisation confers additional rights and protections beyond those granted by indefinite leave to remain. So, for example, indefinite leave to remain can lapse automatically if a person spends a significant continuous period outside the UK, whereas British citizenship cannot be lost in this way. Some further key considerations to think about before making an application to naturalise are as follows. So, first of all, naturalisation is not an entitlement. It is granted at the discretion of the Secretary of State for the Home Department. Additionally, the UK permits dual nationality, but not all countries do. Therefore, it's really important to consider this before applying, as obtaining an additional nationality can impact other nationalities that are held. So in terms of the process of actually making the application, it is made via an online application form, which we've included a link to here. Applicants will be required to pay the relevant fee for the application. The fee is currently £1,500 with an additional £130 citizenship ceremony fee. Both elements of the fee are paid at the same time of submission. Applicants will then need to book a biometric appointment and upload their supporting documents before attending their appointment. If the application is successful, the applicant will need to attend a citizenship ceremony, and this must be attended within 3 months of receiving that invitation. One thing to note here is that the applicant does not actually become a British citizen until the point at which they've attended their citizenship ceremony and received their certificate of naturalisation. It can take up to 6 months to receive a decision, and unfortunately at present there are no expediting services for these applications. So providing referees is an essential part of a naturalisation application. Each applicant must provide 2 referees and they must meet a specific set of requirements. The referees must have known the applicant personally for 3 years. They must not have had any imprisonable offences in the last 10 years. They must not be related to the applicant or the other referee by blood or marriage. They cannot be the applicant's solicitor and they cannot work for the Home Office. One referee can be a person of any nationality who has professional standing, and the second referee must be the holder of a British passport and either a professional person or over the age of 25. So then what do I mean when I say the referee must be a professional person? An acceptable professional person is a person who falls within a list of accepted professions. So you can see the linked nationality policy guidance here, which provides this list at page 25. There are a really good number of professions on this list. That can include accountants, dentists, teachers, police officers, to name just a few. It is very important to consider referees before making the application, as this can potentially be a roadblock to an otherwise straightforward application. If a person, it can potentially be a roadblock if a person struggles to provide referees who meet those necessary requirements. I'm now going to hand you over to Carla, who will take you through the next sections of the webinar.
Thank you, Cathryn. Okay, then, so I'm going to take you now. So my name is Carla Mirallas Martinez, and I am a solicitor at Carta Thomas. I will now be covering the eligibility requirements to apply for naturalisation. There are mainly 2 routes to naturalise, and those are under the British Nationality Act 1981, Section 6 and a Schedule 1. The main 2 routes are the 5-year route under Section 6.1. Those are for individuals who are not married to or are not the civil partner of a British citizen. Those individuals must have been free from immigration restrictions for at least 12 months, and that usually implies they have been granted indefinite leave to remain, otherwise known as settlement. There's also the 3-year route under Section 6.2, and this is designed for individuals who are actually married to or the civil partners of a British citizen. In this case, there's no requirement to have been free from immigration restrictions for 12 months. This means that someone who is married, for example, to a British citizen, after they have been granted indefinite leave to remain, they can straight away apply for citizenship without having to wait 12 months. There are also alternative routes for those who are in Crown service or if they're spouses or civil partners of a person in Crown service. In terms of the eligibility requirements, here we have listed the main requirements, which are that, first of all, the person has to be age 18 or over. As Cathryn said earlier, these applications for naturalisation involve adults. They must be of sound mind. This requirement is specifically to ensure that applicants can comprehend the actions in applying for citizenship. Residence requirements, so they will need to meet all the residence requirements, which we will explore in a second. They will have to have a good character. The future intentions requirement must be met. Again, that will imply if the application is successful, the applicant needs to show that the UK will be their place of residence. However, this requirement does not really apply to applicants who are the spouse or civil partner of a British citizen. Therefore, those who are applying under Section 6.2 of the British Nationality Act 1981. And all applicants must have knowledge of English language and life in the UK test. First of all, we're going to be looking into the residence requirement for those who are non-spouses or civil partners of a British citizen. So the first route, the 5-year route. Because it's the 5-year route, implies that the applicant must show that they have been in the UK 5 years prior to the date of application. In regards to this point, in practice, it is advisable for applicants to provide evidence that they were physically in the UK on the first day of their qualifying period. And that could be simply by providing a bank statement showing transactions in the UK on that day. We have encountered situations where the Home Office have requested this information. Aside from this requirement, there's also other residence requirements. So those applicants not married to British citizens must have spent no more than 450 days outside the UK in the last 5 years, and no more than 90 days outside the UK in the last 12 months. They must also have been free from immigration restrictions for the last 12 months, meaning they have been granted and they have been holding indefinite to remain for the last 12 months, and they have not been in breach of any immigration laws in the last 5 years. What happened when someone has exceeded the limit of absences? Well, the Home Office policy guidance established that some discretion can be exercised in certain situations. For those who are not, again, the spouse or civil partner of a British citizen, as we said, the general rule, the main starting point is that they cannot exceed more than 450 days in the last 5 years. However, if that number goes up until 480, discretion is usually disregarded. Sorry, the absences are usually disregarded. If the absences go over 400 days, but less than 900 days, discretion would then be exercised in certain situations. Again, all of this is further explained in the Home Office policy guidance and the set of circumstances that we'll be applying on those cases too. Another rule that is very important to meet is the absences in the final year. So not only the absences in the last 5 years are important, but also all the absences that happen in the final year before making the application. And the main rule is that those absences cannot be more than 90 days. Again, the Home Office policy guidance establish some discretion to be exercised. For example, absences of up to 100 days are usually disregarded. And if absences are over 100 days, discretion may be exercised in certain circumstances. It is important to note when it comes to these two residence requirements, especially on the qualifying period, the 5 years, that the discretion on the qualifying period, on the 450 days limit, will be considered if the applicant meets the other requirements. And these include not only the good character, the life in the UK test, etc., but that also includes the requirement of not having fine absences of over 90 days in the last final year. So it's very important to look at the absences overall, and especially if relying on discretion to be exercised in the last 5 years, you need to make sure that the absences in the final year are within the limits. For those who are spouses or civil partners of a British citizen, the qualifying period is shorter. Instead of 5 years, they have 3-year qualifying period. Therefore, they also need to show that they were in the UK 3 years prior to the date of application. In terms of the absence limit, they must show that they've not been in the UK, they've not been abroad for more than 270 days in the last 3 years. And the same rule applies in regards to the last 12 months, and that would be a limit of 90 days. They also need to show they are free from immigration restrictions at the date of application, for example, by having indefinite to remain, and not in breach of any immigration laws in the last 3 years. In regard to the last requirement of not in breach of any immigration law in the last 3 years, this comment goes for them and also for those who are non-spouses. This is usually met, so a person can be treated as meeting this requirement without further inquiries if they hold indefinite to remain. So usually those who have indefinite to remain will meet that requirement kind of automatically in both situations. Again, there are also discretion that can be exercised regarding absences for those who are spouses of British citizens or civil partners. The absences are that if the person exceeds the absence from up to 300 days, those absences are usually disregarded. If absences are over 300 days, but less than 540 days, again, discretion may be exercised in certain situations. And all of these situations are described at length in the Home Office policy guidance. And the absences in the final year should be no more than 90 days, exactly as the rule for those who are non-spouses or civil partners. And the same rules apply here. So absences of up to 100 days are usually disregarded, and over 100 days discretion may be exercised in certain situations. The good character. The good character is another eligibility requirement. The requirement for a person to be of good character in order to naturalise as a British citizen is also set out in a Schedule 1 to the British Nationality Act 1981, Section 41A of the same Act, as introduced by Section 58 of the Immigration, Asylum and Nationality Act 2006, extended the good character requirement to a specific routes to registration as a British citizen also. The problem with the BNA, the British Nationality Act 1981, is that it does not define good character. However, the Home Office good character policy guidance set out the type of conduct which must be taken into account when assessing whether a person has satisfied the requirement to be of good character. So very important here always to refer back to the Home Office guidance on good character. The guidance established that consideration must be given to all aspects of a person's character, including both the negative factors, for example, as criminality, immigration law breaches, and deception, as we will explore in a minute, but also positive factors, for example, contributions that a person has made to society, etc. So the list of factors that we will be exploring is not exhaustive. And also the Home Office guidance is clear that each application must be carefully considered on an individual basis on its own merits. The Home Office must be satisfied that an applicant is of good character on the balance of probabilities. And to facilitate this, applicants must answer all the questions asked of them during the application process honestly and in full. They must also inform the Home Office of any significant event, such as a criminal conviction or a pending prosecution, or any mitigating factors that could have a bearing on the good character assessment. One final point on this slide, the good character requirement applies to a person who is age 10 or over at the date of application, okay? However, when assessing whether a child is of good character, the Home Office must take account any mitigation circumstances relevant to the child's particularly position and circumstance, okay? So when it comes to what are the factors that are considered when assessing the good character requirement, the classic factor are criminal convictions, okay? So criminality. Now, sentences will be considered in the following way, depending on the date the application was made. So for all the applications made after 31st of July 2023, so all applications made from now on, these are the sentence thresholds. So the Home Office guidance established that an application will normally be refused if the person, for example, had received a custodial sentence of at least 12 months in the UK or overseas, importantly, has consecutive sentences totaling at least 12 months in the UK or overseas, is a persistent offender who shows a particular disregard for the law, has committed an offence which has caused serious harm, or has committed a sexual offence, or their details are recorded by the police on a register. So these are situations that would normally lead to a refusal. The policy guidance then established a set of circumstances where an application must be refused. So less room for discretion, less room to argue mitigating circumstances here. And that's when the applicant has a custodial sentence of less than 12 months, or a non-custodial sentence or out-of-court disposal recorded on the criminal record, and so A or B, and in any of the cases above, the Home Office is not satisfied on the balance of probabilities that the applicant is of good character. So here there is an element which can bring someone with a custodial sentence of less than 12 months can lead to a refusal if the custodial sentence of less than 12 months is in combination with the Home Office considering that the person is not of good character. Factors which will also fall into consideration when assessing the criminal convictions on those sentencing thresholds will be things like the length of the time since the offences, the number of offences, the seriousness, the age of the applicant when committing those offences, etc., etc. Now, where decision is outstanding on an application made before the 31st of July 2023, those sentence thresholds will not apply, and it's the sentence thresholds in the old rules prior to July 23, the ones that will apply. And those are also explained at length in the Home Office policy guidance. Aside from criminality, there's other consideration, there's other factors that the Home Office takes into consideration when assessing if someone is of good character. And that involves things like international war crimes, terrorism, as well as other activities contrary to public good. They will also look at the applicant's financial soundness. For example, whether the person has ever been declared bankrupt, liquidation of companies of which the applicant was a director, whether there are debts, public fund fraud, non-payment of a council tax, etc. So all of those things must be disclosed if it have happened. Notoriety. So that's another one that the Home Office also look at. And that means if the applicant's activities have been notorious and cast serious doubt on their standing in the local community. So that could be something else to be considered. The Home Office also looks at deception or dishonesty. For example, they look at if applicants have been deliberately dishonest or deceptive in their dealings with the UK government, for example, by making a false claim in order to obtain benefits. That could be a classic one for a refusal on the grounds of deception or dishonesty. They also look at immigration-related matters. For example, if someone has breached immigration laws by overstaying, if they have breached conditions, if they have done acts towards evading immigration control, etc. They also look at deprivation. So if someone has already been deprived in the past of citizenship. And important here, this last point on offences of the applicant's children, because the adult applicant must also declare if their children have been convicted for an offence or received a court order. There's a specific question in the application form, and that must also be disclosed with accurate information. In terms of this specific point, the immigration-related issues, that could sometimes be, one of the problems in this type of application. So it could be a reason for refusal. So we have added more notes in this regard. So an application is normally refused if an applicant is the subject of an extant deportation order. So if someone has a deportation order, is probably going to be refused the application. An application is also normally refused for other immigration issues in the 10 years prior to the application. For example, someone accused of entering or someone convicted of entering a sham marriage or receiving a prosecution for a false statement or illegal working. These can also lead to a refusal if it happened in the 10 years prior to the date you make the application. And that would be refused then on the basis of the good character requirement, and there is some discretion relating to children. And immigration, there are also other immigration breaches, for example, relating to lawful residence. And that includes actions like overstaying, illegal entry, absconding, etc. Prior to the 28th of June 2022, those type of immigration breaches, when it happened within the last 5 years, before making the application, were normally a reason for refusal. But that then was changed. The Nationality and Borders Act 2022 amended the requirements for naturalisation and registration so that a person can be treated as meeting the lawful resident requirement during the qualifying period without further inquiry, whether they hold indefinite leave to enter or remain in the UK. Deprivation of citizenship is also important to note here. So a refusal of citizenship can be indefinite in certain circumstances. For example, if a person has been deprived of citizenship on conducive to public good grounds. Okay, so that's one example. And in any event, there's always a possibility of an exceptional grant. Okay, so, and that means situations where on the facts of the case, the application would normally be refused, but in that specific case, there are mitigating circumstances which mean that it would be appropriate to grant. Okay, and that is also covered in the good character nationality policy guidance. Moving on from the good character requirement, we also talked in the eligibility section that all applicants must meet the language and life in the UK test requirements. The life in the UK test currently costs £50. It can be taken as many times as needed. If someone failed, they can do it again, and it does not expire. The English language requirement, it's usually for applications for naturalisation, applicants who provide an English language test. It must be a qualification at CEFR level B1 at least, and from an approved Home Office provider. Of course, those who are nationals of a majority English-speaking country would be exempt from this requirement. And the other way of meeting the English language requirement, if the person has a degree which has been taught in English or overseas but taught in English, they can also provide that academic certificate instead of the language test. Just noting here that if the degree was taught in English overseas, it's not enough with the academic certificate issued overseas. Applicants will also need to obtain an approval letter from ECTIS, which is the organization in charge of looking whether overseas degrees can be comparable to UK degrees, and then they confirm this in the letter, and that will need to be provided with supporting documentation. There are some exemptions to these two requirements for those who are children or over 65, and for those who have a long-term physical or mental condition. One thing that I have to say about this requirement as well is the fact that some applicants, depending on what immigration route they took to get to indefinite to remain, but in most routes, they will need to pass the Life in the UK test and the English requirement test as part of the ILR application. So if they've used those tests on the ILR application, they will then be able to use it again, reuse them, same tests for the naturalisation application. Of course, that is not relevant to EU nationals who, under the EU settlement scheme, didn't need to obtain the language and the Life in the UK test in order to get settled status. The future intentions requirement, as we discussed right at the beginning, that only applies to individuals who are not the spouse or civil partner of a British citizen. And basically, they need to show that they will not break the links with the UK and should not intend to do so in the future. Okay, so they, as part of the application process, they need to show as well that they have the future intention to remain in the UK. This doesn't apply to those married British citizens. And how do they show this? Well, in general, there is a declaration in the application form where they ask whether they have the future intention to remain in the UK, and then applicants should reply to kind of yes to that question in order to meet the requirement if that's true. And so therefore that means that individuals are taken at their word in cases where they meet the resident requirements, they have established their home in the UK, they have absences that are within the limits, and they have family in the UK. So in these kind of situations, them, by declaring that in the form, with all of these other circumstances around them, they should be considered that they meet the future intentions requirement. It is worth noting in this section as well that children under the age of 18 cannot be naturalised. Where a child is included on an application, the Home Office must consider, for example, an adult is including their children in the application, the Home Office must consider whether they are already a British citizen or can be registered as a British citizen, either because they have an entitlement or at the discretion of the Home Office. So that's important. So when assessing children's nationality status, there are a set of questions that one needs to make, which are, is the child already a British citizen? In this case, they don't need to be registered, or they don't need to be included in the parent's application. They can simply go and apply for a British passport. Secondly, if they're not already a British citizen, is the child entitled to register as a British citizen? In those cases, they can then be included in the parent's application. And then there are different entitlements to register. For example, we're just giving here a few examples. Children who are born in the UK, who have lived continuously in the UK for the first 10 years of their life, who have spent no more than 90 days outside the UK in each of those 10 years, and providing they are of good character, they could register as British under Form T. Just also worth noting that adults can also use Form T to register as British rather than in those situations if they meet the requirements. And in those cases, they don't need to apply to naturalise. Another example of those who are entitled to register could include as well if the parent of the child has settled or naturalised after their birth in the UK and the child was born in the UK, so they might also be able to register after they have granted ILR or naturalisation. If the child was born abroad to a British by descent parent, they might be entitled to register in also in certain circumstances. And these were only examples. Now, we looked at whether the child is automatically British, whether the child has an entitlement to register. And then other important questions include, does the child fall within the normal criteria for registration? Or are there exceptional, compelling, and compassionate circumstances in the case? So all of these things will need to be important in assessing a child's nationality. So I finished now with my section. I'm now going to be handing over to Cathryn, who will also take you to the case study.
Thank you, Carla. I'm now going to have a quick look at a case study to apply these requirements to a fairly typical situation. So in this scenario, we have X. X entered the UK on the 7th of June 2019 as the spouse of a British citizen. He applies for ILR, so indefinite leave to remain as a spouse, in June 2024 after completing his qualifying period on the 5-year partner route. So his application was successful and he was granted ILR on the 5th of September 2024. So the question is then, when can X apply to naturalise as a British citizen? Because X is the spouse of a British citizen, he doesn't have to wait 12 months following the grant of his indefinite leave to remain. He can then apply immediately to naturalise, provided that the other requirements are met. He will need to have lived in the UK for the last 3 years. He will need to have been physically present in the UK 3 years prior to the date that he makes his application. He should not have spent more than 270 days outside the UK in the last 3 years, and no more than 90 days in the last 12 months. So therefore, even though X is the spouse of a British citizen and is only required to show 3 years residence for his naturalisation application, he has actually been required to reside in the UK for 5 years in any event, due to having settled on the partner route. Another interesting point here is that the residence requirements for naturalisation are stricter than the partner route in terms of the number of absences a person is permitted to have. So therefore, individuals who are on the partner route and are planning to naturalise after they've settled will want to bear in mind those absence limits for naturalisation during that time they hold permission as a partner. And that brings our webinar to a close. If you do have any questions about the naturalisation process and whether you meet the necessary requirements, or if you have any general questions regarding an immigration matter, please do reach out to us. We'd be more than happy to assist you. Our website, which you can see here on this slide, also has lots of information relating to naturalisation applications, and you can also see our contact details here on this screen if you'd like to get in touch with us. So thank you so much for joining us today, and we hope that you enjoy the rest of your day.
Thank you for attending. Bye-bye.